Hare Krishna. Welcome to Tax Guru YouTube channel. This is CA Rohan R. Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. And today I am going to conduct special video on a topic issue of notice under section 148A, that is reassessment, without furnishing underlying material. So let me allow to share my screen. Reassessment notice under section 148A, and that is also issued without underlying material to the assessee. So let's understand background of reassessment. Okay, reassessment proceedings under the Income Tax Act have historically been a significant area of litigation due to their intensive nature and potential impact on taxpayer certainty. Recognizing the misuse and mechanical issuance of reassessment notice under Eastwell sections 147 to 151, the legislator introduced a new reassessment regime with effect from 1st April 2021. A key safeguard introduced under this regime is Section 148A, which mandates a preliminary inquiry and opportunity of being heard to the before the issuance of notice under section 148. The provision seeks to balance what the interest of the revenue with the principles of natural justice. One of the most contentious issues under the new regime has been the issuance of notice under section 148A clause B without furnishing the underlying material or information relied upon by the assessing officer. So our today's lecture or video is focused on that particular part, that is section 148A clause B. Let's understand statutory framework of section 148A. Section 148A lays down a mandatory pre-notice procedure before issuing a reassessment notice under section 148A. 148, the provision contains four distinct steps. First, section 148A clause A, that is inquiry with approval, that is conducting inquiry if required with prior approval of the specified authority. Then second, section 148A clause B, that is show cause notice and opportunity of being heard, that is providing the assessee an opportunity of being heard by issuing a show cause notice containing information suggesting escapement of the income. Then third, section 148, third and fourth is section 148A clause C and clause D. That is consider reply and pass reason order. That is the considering the reply of the assessee and after that passing a reason order, deciding whether it is fit case for issuance of notice under section 148 or not. The focus of this lecture, as I said, is section 148A clause B, that is show cause notice and opportunity of being heard. That is the foundation of reassessment proceedings under the new law. Let's move on further. Meaning of information suggesting what escapement of income. The term information has been specifically explained in explanation 1 to section 148 that includes entirely information flagged under risk management strategy, audit objections, information received under exchange of information provisions, information arising from search or survey proceedings in other cases. However, mere existence of information is what not sufficient. Such information must be shared with the assessee is what is important to enable the assessee an effective opportunity of being heard. So let's see requirement of furnishing underlying material. That is a conceptual analysis. What effective opportunity requires what? Disclosure of material relied upon what assessee must know exact allegations and basis. That is the opportunity of being heard under section 148A clause B is not an empty formality. It is not at all empty formality. For such opportunity to be meaningful, the assessee must be informed of the exact nature of allegations. The assessee must be supplied with what material, documents, or data relied upon by the assessing officer. Vague references such as information received from inside portal or risk parameters are insufficient. Please note down this. Vague references such as in the notice itself, information received from inside portal or risk parameters are insufficient. Non-furnishing of underlying material renders the opportunity illusory and ineffective, violating principles of what natural justice. Let's next understand the principles of natural justice, Audi Alteram Paratum. That is the principle of Audi Alteram Partem. That is the here the other side. What is meant by it is here the other side is embedded in tax jurisprudence. Courts have consistently held that no person can be condemned unheard. Hearing must be effective, real, and meaningful, not ritualistic. Disclosure of material relied upon is an inseparable component of fair hearing. Section 148A is a statutory embodiment of what natural justice, and its non-compliance vitiates the entire reassessment proceedings, means it can be a void ab initio. So it is very, very important. Let's understand next judicial approach on non-furnishing of material. Courts across the jurisdictions have taken a consistent view that failure to furnish underlying material relied upon in section 148A clause B notices is fatal one, and the following broad principles emerges from the judicial pronouncements. What are they? The assessee cannot be the assessee cannot be expected to rebut allegations without knowing the basis or thereof. Supply of only conclusions or summaries is not sufficient at all. The AO must disclose all material that forms the basis of his belief except where disclosure is expressly barred by the law. So subsequent furnishing of material cannot cure the defect if the initial opportunity was vitiated. Very important. What it is also heading is that the subsequent furnishing of material cannot cure the defect if the initial opportunity was vitiated. So such reassessment notices and consequential orders under section 148A clause D have been quashed by the courts. Very, very, very important. Let's understand distinction between the information and evidence. Okay. A frequent argument by revenue is that section 148A requires what? Disclosure of information and not evidence. This is the revenue's argument that section 148 requires what? Disclosure of information and not evidence. So courts have rejected this narrow interpretation by holding that information must be supported by what? Tangible material. Okay, information must be supported by tangible material. If the AO relies on documents, statements, or data, the same constitute part of the information. So artificial bifurcation between information and material defeats the purpose of section 148A. Thus, all material forming the basis of the proposed reassessment must be furnished to the assessee. Let's understand common defects observed in section 148A notices. In practically the following defects are frequently noticed. What are they? Notices merely stating that information suggests escapement of income without any details, non-supply of third-party statements or documents relied upon, reliance on investigation reports without sharing the extracts of the report, extremely short time granted for reply, compounding the prejudice. So such defects have been viewed seriously by the courts. Next, consequences of non-furnishing of underlying material. Means what are the consequences? Failure to furnish underlying material leads to violation of section 148A clause B, breach of principles of natural justice, invalidation of order passed under section 148A clause D, and quashing of subsequent notice under section 148A. So importantly, these defects are considered jurisdictional in nature. It is not a procedural, but it is a jurisdictional in nature and curable procedural irregularities, and not curable procedural irregularities. It is not at all curable. It is went into the root of the cause. Next, remedies available to the assessee. Let's see what are the remedies available to the assessee. An assessee aggrieved by such defective notices may immediately file detailed objections highlighting the non-furnishing of material, seek copies of documents and information relied upon, approach the High Court under weak jurisdictions where the notice is patently vague or the opportunity is illusory or jurisdictional conditions are not satisfied. So courts have entertained that wheat petitions at the section 148A stage itself in appropriate cases. So this we need to be keep in mind. Let's see practical guidelines for professionals. Chartered accountants and tax professionals should examine whether section 148A clause B notice encloses or refers to the specific material. Insist on complete disclosure before filing a reply. Record objections on violation of natural justice at the earliest stage and maintain a distinction between merits of the case and jurisdictional defects. Very important. So proper handling at the section 148A stage can often avoid what prolonged litigation. So we need to be prepared before once the notice received. We need to check all these items whether they are supportive, the whatever actions they are taking or whatever information they want, whether they are supported by that data or any statement. So we need to check first that. So now the concluding we need reach to conclusion part that section 148 ensures what transparency and fairness. Section 148 marks what paradigm shift in reassessment law by embedding procedural fairness into the statute itself. Issuance of reassessment notices without furnishing underlying material defeats what the very objective of the new regime. Judicial scrutiny has reinforce that transparency, fairness, and accountability are non-negotiable in reassessment proceedings. Both tax administrators and taxpayers must appreciate that adherence to the section 148A is not a mere technicality but a substantive safeguard itself. So it is compliance benefits both the revenue and taxpayers. So thank you so much for patient hearing. Please note down my contact numbers. If you have any suggestions, observations, any queries, then do let me on the mentioned contact numbers. So be connected to Tax Guru YouTube channel. If you are not yet subscribed, then do subscribe Tax Guru YouTube channel for latest updates and videos like this. So stay tuned to the Tax YouTube channel. Bye bye. Take care. See you soon. Hare Krishna.